This is almost September. Okay, cool. All right, so we're live. Hey everybody, it is Monday night, a little after 7:07-ish. I'm Carol Williams. I am the managing attorney at Williams Immigration. I run a boutique immigration law firm where I help businesses and families navigate our U.S. immigration system. So we help everybody get work authorization, green cards, travel permission, U.S. citizenship, and do some compliance work as well. So I wanted to come live to you tonight. I come live to all Monday through Thursday evenings, roughly around 7 p.m. Eastern. And I wanted to give you all some updates and answer some questions, any questions that you may have. As a reminder, I am an attorney and I am an immigration attorney, but I'm not your immigration attorney. So all the information in this live and all my other lives is really general information for you all to take with you. It is not legal advice. If you want legal advice, then we have to set up a consultation. There's a whole process. So some of the updates that I want to give to you all are, let me look at my notes here because we got some, I wrote them down. If you're applying for a non-immigrant visa, so if you're applying for like an H, an L, an O, a temporary visa, right? Not a green card, but a temporary visa, you now have to do that in your home country or your country of last residence. That came out this weekend on Saturday from Department of State. So if you already have an existing appointment, Department of State has said existing visa appointments will, quote, generally not be canceled. Not quite sure what that means, but hopefully they will not have to cancel any of the ones that have already been scheduled. But that is a significant change. It is a move back to how the Immigration Service used to do things. It used to be that you pretty much had to process any of your visas in your home country or your country of last residence. Maybe a month or so ago, last month, the Immigration Service and Department of State also said that if you were applying for a green card, sometimes called consular processing overseas at a consulate, that application also had to be done at your home, in your home country at the U.S. consulate. So those two things. Third thing, if you are applying for a non-immigrant visa to come to the U.S., more than likely now you will need to have an interview. So that means those three things. So making people apply in their home countries, it is part of the administration's deeper security vetting. The reality is it's just easier for them to vet if someone is at a consulate in their home country. The folks that work on that consulate see birth certificates, death certificates, marriage certificates, all the various local and or nation countrywide documents. They see those documents all day, every day, and they are much better able to judge if those documents are real, if there is something fraudulent about them. But those three things combined mean that high volume consulates are going to absolutely see a backlog begin. There is no way that we are processing all of the green cards, all of the non-immigrant visa applications, as well as requiring interviews for those non-immigrant visa applications, and that we wouldn't see a backlog start to create, right? There's a lot of applications out there. There are a lot of people out there. So we'll see how it goes. But my crystal ball, which I always tell you guys is a little cloudy. I don't think it's very cloudy on this one. I think we're going to see some backlogs. I don't see how we cannot. So if you are processing a green card overseas, if you are processing a non-immigrant visa application overseas, and the non-immigrant visa application situation is effective immediately. So it was effective on Saturday when they posted this for us. If you were gonna hop online and get your visa appointment this morning or tomorrow or sometime this week or sometime next week, it was on your list of things to do, and it was to do in a country that was not where you are a citizen or your country of lost residence. So you're going to have to redo that. You're going to sort of rethink that. I talked about this on my live this morning on LinkedIn. Employment-based preference category number 2. So EB2 is unavailable for the rest of the fiscal year for all countries. So what does that mean? It means that individuals that have EB2 green cards pending, so either they're at the NVC stage or they're at the 45 adjustment of status phase, it means that they will not have, and the government will not process any more EB2 green cards for the remainder of the fiscal year. So that is the bad news. The good news is that the fiscal year ends at the end of this month in September. So, and we will sometimes see some categories go completely unavailable in September. We can look at it a couple of ways. You can be upset about it, and I get that. You could also look at it as, at least it happens in September. So there's only sort of a month, in this case, a little less than a month of time where they are not processing these particular green card applications. Silver lining is that October 1, they will be ready to go again and able to process. Also silver lining is that they are using up all of the visa numbers for this particular category. So all of these visa numbers are being used. So that is something good as well. That's just a good way to look at it. What else do we have by way of updates? So those are kind of some of the updates that we have. Oh, another big update I want to tell you is that the Immigration Service, USCIS, will know, or is, the USCIS is transitioning to being a much, well, not much, to being a more electronic agency. And so the next thing that they are doing is they are eliminating the ability to pay your filing fees using a check or using a money order, using any paper, as of October 28th of this year. So as of the end of next month, the way that you're going to pay your filing fees is via credit card. Now, I've had this question in my own practice, so I will let you know. Credit cards, if you're paying via a credit card, and as of October 28th, you will be, must be drawn on a U.S. bank. So if you are currently living overseas and you have a Visa or a MasterCard, that's not enough. It has to be, the funds have to be coming out of a U.S. bank. So that is something that you need to think about. If that is sort of not your situation right now, maybe you don't have a credit card, that is something that you're going to need to consider. And so that is something that I talk with my clients about in terms of getting those filing fees handled. So think about that. That's coming next month. I don't see them stalling on that, but that is absolutely coming next month. So just a few things that have happened in the past week and a half-ish that I want to talk to you guys about. So if you have any questions, general immigration questions, you are welcome to put those in the chat. I will do my best to answer them. As a reminder, while I am an immigration attorney, I'm not your immigration attorney. So all of my answers, all of your questions are really for educational purposes. I cannot give you, nor would I give you legal advice on a social media platform. So keep that in mind as you're asking questions. But I love to hang out with you guys Monday through Thursday, around 7 o'clock at night. Thanks for the likes, guys. I appreciate that. Let's see, what do we got here by way of questions? And if you guys don't have questions tonight, that's totally fine. As you all know, I always eat dinner after I go live. So that just means I get to dinner a little bit quicker. Why is my VAWA work permit going on to 7 months with no updates? I don't know. To be honest with you, I don't know. My office generally doesn't handle a lot of VAWA cases, so I don't know what the general processing time is. So I don't know. I don't know why it's going on 7 months. That could be completely normal. It could be completely out of the range of normal. I don't know. You may want to check online. You want to check the USCIS website and see if they have processing times for VAWA-based work permits, and that may give you a little bit of an indication of what they are currently processing. Someone is saying, can they really appoint lawyers as immigration judges? So I have not personally looked at the provisions under which they are doing that. So sort of the short answer to your question is I don't know. I don't know. I have not actually looked at those provisions. But this does make me think of something that I think you guys should know. Immigration attorneys, we all don't handle all facets of immigration work. So because most of my clients are not filing, or we are not in deportation proceedings, as I have to, I've got the same number of minutes and hours in a day as everybody else. And so I've got to really sort of balance and prioritize my time. And so I just haven't had a chance to dig into that a little bit more, and really look at it, in part because it does not, at this point, impact my clients as much as some of the other things that are coming out. So I unfortunately don't actually know. I have not looked at the legal provisions that they've cited in saying that they're going to do that. So we'll see. I do know other colleagues that have, but I just haven't had the chance to do that yet. But it's a good question though, and I appreciate the question. Do USCIS officers scan your whole VAWA application? What's your experience? The short answer is I don't know. The applications typically that I tend to work on, yes, we've been told by USCIS that those are scanned. So I don't know if there would be a difference in the way that VAWA cases are treated. VAWA cases are very sensitive and the agency takes them very seriously. So I don't know if they are scanning entire VAWA applications. That I don't know. Maybe they're scanning part of the VAWA application. That I have no idea. So my experience is not very big with that. Sorry. So yeah, I don't know. I don't know the answer on that one for you. Hold on. Let's see here. Hold on. Took me all the way to the bottom. So let me go back up a little bit. Next question. Someone's asking, how did you conduct interviews with those who had a criminal background? So I did not ever conduct an interview when I was at USCIS. I was an adjudications officer over policy issues, and so I was at headquarters in DC. So I was not in a local office. Like I wasn't in the local office in the DC area, seeing folks that had filed their applications. All of my work was done at headquarters. So I can't really sort of give you any sort of insight from that perspective. I can give you insight from the perspective of being an attorney. When folks have criminal issues, it is a criminal background. It's super, super important to work with an attorney who can do an analysis of the specific crimes in your criminal background, and make sure, or not make sure, but look at the impact that criminal background may have on the type of application that you are applying for. It is not enough to say, oh, it's a misdemeanor, it's fine, or oh, it's a felony, therefore it's not fine. There are some misdemeanors out there that can be seen as felonies in the immigration world. So that is a very complex intersection of law when we're talking about immigration benefits and criminal law. So I would say, I think it is best if people who have a criminal background that they work with a lawyer on their case. But as for your initial question about how do actual officers handle them, I can't answer from an officer's perspective. My officer title was a little bit different than I think most people sort of think. I was at headquarters. Someone else is asking, Billy Summit 86 is asking why is my status still the same from months ago? Something about the mail being returned to USCIS. Is the status that the mail was returned, or are you saying your mail was returned and whatever the status online is saying is the same? So I'm not quite sure which one you mean there, but depending on where you are in your case, so if you have had, and depending on what kind of case you filed, I don't know. If you have filed your case, gotten your receipt notice, if your case requires biometrics, or if they have sent you a biometrics notice, oftentimes there's nothing else left for you to do but wait, which nobody ever wants to hear, but that is the process, right? We file, we get a receipt notice, which is great. I know that the Immigration Service has the application, and we get the receipt notice, and then if, depending on the type of case, if biometrics are required or needed, then we get a biometrics notice. Truly, then we just wait. If you want to know the processing time for your case type, you can go onto uscis.gov and pull the processing case, or pull the processing times from the USCIS website, and that will tell you if your case is sort of outside of their current processing times. So hopefully that's helpful. Let's see here. Someone is asking about applying for a green card and you've had a previous controlled substance case. The first thing I tell people to do if they are working with me on that is I need some details, right? And I'm not going to ask you those details here on social media, but just so that you all have an idea of kind of how this plays out when you work with an attorney. Great. So there's a controlled substance case in your history. Okay, I need to know more about it. I need to know the facts surrounding it. I need to see the actual criminal documents. Then we've got to look and do an analysis of what are you applying for in terms of an immigration benefit. Like, what benefit are you applying for? Are you applying for a green card? Are you applying for a non-immigrant visa? Are you applying for citizenship? What are we applying for here? And then we've got to look at the actual statute from the actual law from that criminal case. Not a summary, not what your friends told you, not what you understood it to be, but the actual words on the page of the law at the time the case happened. Laws change, so I can't use what the change from today. I've got to use whatever it was when you had the criminal issue. And then we look at the law as it's written on the criminal side and what does that mean for your green card application. So my thought is that you should have a conversation and work with an attorney who can do that analysis for you. It's not an analysis that is, nor should it be done quickly. There is some thought and care that needs to go into that. And then once once an attorney sort of gives you their legal opinion, then you've got some decisions to make, right? Do you continue with the application? Do you not continue with the application? And I often tell people those are the decisions I can't make. I can give you information, but then at the end of the day, you've got to be the one to actually make the decision. And for some folks, that is kind of the hard part. How should I prepare for a marriage green card? The green card interview is an opportunity for, well, first and foremost, is an opportunity for a conversation, right, between the couple and the immigration officer. There's an opportunity for a conversation. During that conversation, it is the officer's job to determine that this marriage is not a sham marriage, that this marriage is a real marriage, that this marriage is not solely entered into for the purpose of getting a green card. So the officer is going to ask questions about your relationship. How did you meet? How did you propose? What day did you get married? That sort of thing. The officer is going to ask you about your life together. I prepare my clients. I do mock interviews for them so that they feel prepared, so that they know what's going to happen during an interview. And so they have told me that they find that helpful. They've also told me that they thought I was much meaner than the officer, which I'm okay with that. I'm completely okay with that. I would rather them think that I'm mean than the officer. I'm 100% okay with that, but I like them to go in feeling prepared. And so my mock interviews are kind of designed for that. And I also will do mock interviews for folks that aren't my clients. But yeah, you should be prepared to talk about your relationship. Let's see here. Someone's asking, I will do my second request for resident permanent. Will I have a problem with the new administration? Sorry, and you're very welcome. I hope that was helpful. So in terms of applying for, I believe you're asking, now you're applying for your green card a second time. Will that be a problem? Depends, right? So the short answer is I don't know, because I don't know, all of the facts of your case or what have you, or your situation. But I have definitely worked with clients who have applied for their green cards more than once. That is very, very fact specific. I would recommend that you have a conversation, a consultation with an attorney, and tell them what's happened in the past, and see how they can help you. But yeah, applying for a second time does not automatically mean that you are going to get denied. I guess is kind of the easiest way to put it. Let's see here. My status is still, quote, interview as scheduled, even though I had the interview on August 22nd. Okay, y'all, listen. I know that you want your case done. I get that. I do. I absolutely sympathize with that. I am not the most patient person in the world. But August 22nd to September 8th is not a long time. It's not. It's not a long time in immigration world. It is not a long time outside of immigration. It is just not a long time. What people, I think, maybe don't understand, so I want to explain that to you all, is when you walk out of your green card interview, or when you walk out of your citizenship interview, and sometimes citizenship is a little bit different. Sometimes they'll approve you right then, and then you can get sworn in the same day. But for sure, when you walk out of your green card interview, the officer still has work to do on your case. There is work that still has to be done in the background. Even if they say to you, I'm going to recommend your case for approval, right? So you have to give the officers time to do their jobs. Just like you and I, when we go to work, right? Like we need time to do our jobs. So they need time to do their jobs. So if you just had your interview on August 22nd, like you've got to be patient. You've absolutely got to be patient. Things are not gone are the days when I would go into an interview with my client, and at the end, the officer would say, "You're approved." They would turn around to their desk. They would unlock usually their top cabinet. They literally had a key to it. They would unlock it, and they would pull out a stamp, and it's called an I-551 stamp or an added stamp, and they would stamp in your passport that you were now a green card holder. Those I have not seen them do that in. I cannot even tell you how long. Those days are over. Those days are absolutely over. I would love to know that they're still doing them somewhere in the States, but I've not seen those. Things are, it's going to take some time. It's going to take some time. So unfortunately, you're going to have to wait just a little bit longer. And also remember, y'all, like 30 days in our world, in our immigration world, it's like 3 seconds in like real time, right? Like it's honestly, to me, that's like the equivalent of like 3 seconds. That is a fast turnaround for the immigration service. So I understand that you're still waiting. I understand that you don't want to be waiting, and I completely understand that, and I sympathize, but you gotta wait. You gotta wait. Like you are nowhere near like being past processing times. Oh, we answered that one. My case has been 10 months now. My I-45 moved to still processing. What does that mean? It means your case is still processing. I mean, the reality, depending on what your category is, if you're in a preference category, it could mean your case isn't moving at all. Like and some people don't really like my honesty here, but it could mean your case isn't moving at all, right? This is one of the benefits of working with an attorney. I give my clients processing times. And I tell them, I was like, listen, I was like, immigration is a game of hurry up and wait. Nobody likes waiting, myself included, but it is a game of hurry up and wait. And depending on the category of your case, 10 months might not be that. 10 months might be well within processing times. If you are concerned that 10 months is too long, you can always go on to the USCIS.gov website and check the processing times. That will give you an indication of roughly how long it's taking them to process 70 to 80% of the same case type as your own. But yeah, 10 months might be way too long. 10 months might not be nearly long enough based on the current processing times. What else? Does TPS still have rights or no for Venezuela? I do not know off the top of my head. I believe TPS for Venezuela was ended. I do not know what that specific end date is. That is something I would actually have to look up. I do not know that off the top of my head. What is an example by mock questions during U.S. citizenship interview? A USCIS officer, when you go in for your interview, they are looking to see whether or not you have a real marriage, whether or not you married simply to get a green card, whether or not there's been sort of pay to play in terms of this green card. So when I do mock interviews, I ask my clients questions about their relationship. The officer is going to ask you questions about your relationship. That's what they want to know about. so that they can get a sense of whether or not this is in fact a real relationship. Let me see here. Hello, my cousin. He wants to apply for an N-400, which is citizenship, and has a criminal arrest, but dismissed past 5 years ago. So when you apply for U.S. citizenship, you have to show what's called good moral character. Good moral character, generally speaking, there are several facets that the immigration officer can look at. But think of, do you have a criminal background? Have you paid your taxes? If you haven't paid your taxes all at once, do you have a payment plan in place? Have you been paying child support? Have you been paying the alimony that you're supposed to be paying, either inside the U.S. or outside of the U.S., right? So it's kind of like a law-abiding person, right? Generally, the agency will look back 5 years, unless you're married to a U.S. citizen, and then they look back 3 years. But they look back 5 years. So can they go back past the 5 years? Yes. Will they? Yes. Sometimes they will. So again, it's really something that you would want to have a consultation with a lawyer about, or your cousin will want to have a conversation with a lawyer about, and see what that criminal background and that arrest entailed, and what happened, and how it may or may not impact a citizenship application. But anytime there is a citizenship application and a criminal background, I always recommend that people work with attorneys on those. Someone is asking, are people with conditional green cards at risk for deportation or ICE harassment when going in foreigners? I don't sort of quite understand your question. So I don't actually understand your question, but I will say this. Conditional green cards are issued to folks who process their green card through marriage to a U.S. citizen, and they have been married for less than 2 years at the time the green card is approved. They're given conditional permanent residence. Their green card is valid for 2 years. At the end of that 2 years, they need to remove the conditions. That is a whole other application with the Immigration Service. If they remove the conditions successfully, then they are a true lawful permanent resident and they get a 10-year green card. If you are a conditional permanent resident or a lawful permanent resident, you can be placed into deportation proceedings. Being a conditional permanent resident or a lawful permanent resident does not shield you from being placed into deportation proceedings. So is that person who's a conditional permanent resident at risk for coming into contact with ICE? Absolutely. Ideally, they have done nothing that would place them into deportation. But conditional green card or lawful permanent residence is not a bar. It does not shield you from potentially being placed into deportation if there is a reason to place you into deportation, right? So hopefully that is hopeful. It looks like someone is saying yes, he got a lawyer, and he has court disclosures. So perfect. If he has a lawyer, he should be having these conversations with his lawyer, and listen to the lawyer as they guide him through, or he should listen to the lawyer as he's guided through. Let's see here. Do they approve hardships for marriage-based cases due to mental health? Completely depends on the application. Completely depends on the documents. I get questions like this all the time, whether it's an employment-based case or a family-based case. The Immigration Service is not going to approve anything just because I ask them to. Like my ego would love if they did, but they are not going to do that. That's not at all how things work, right? They have to have documents in front of them to review. So even if I have the most believable case, like the best case I think I have ever had, right? If there are no documents to support what I am trying to argue, the Immigration Service will absolutely deny my case. They will. So will they approve a hardship case for marriage due to mental health? I don't see why they wouldn't, as long as documents are submitted that help them do their job, that show that a waiver based on hardship should be approved, right? I cannot stress this enough. It doesn't matter. I tell my clients this all the time. It doesn't matter that I believe you. It doesn't. It doesn't matter if I write the best brief in the world. It doesn't matter if I don't have evidence to pull from as I write my brief, or I don't have evidence to give to the Immigration Service, your case will absolutely get denied. I have people that have tried to do things on their own, have filed, didn't file enough information, didn't know the information that they were supposed to file. They file it. The Immigration Service gives them a gift of a request for further evidence. And I mean, it's a gift. It is a gift, right? You get a second shot at the apple, is how I tell my clients to think about an RFE. The Immigration Service is still talking to us, and I appreciate that. And so they've come to me and they were like, I don't know what else I should have put in here. And we take a look at it and I can come up with all sorts of things I should have probably gone in that first application, right? You have to give the officers something. You've got to give them documents. If they don't have documents, they may feel sympathetic for you, but they cannot approve you. So giving them, it's kind of a help you sort of situation. We've got to give them documents that they can look at. And this is not to say that I like all of the contents of the RFEs that I get. I'm not saying that at all. But it is always a second shot at the apple. People are asking questions about owing taxes in a green card context or things like that. Let me say this. One U.S. government agency is not going to give you a benefit if you are not in good standing with another government agency, right? They're not going to do it. So if you are not paying alimony, if you are not paying child support, if you have tax debt that you have not put into a payment plan, all of those things, and there are other examples. These are just sort of the frequent ones. All of those things need to be handled prior to an application. And those are really like they're easier to handle prior to filing, because prior to filing you have all the time in the world to handle those issues, right? The second we file and they give us an RFE, we've got 12 weeks. And so you've got 12 weeks to handle it. You've got 12 weeks to get square with another government agency. Well, if you don't like the 30, 60, 90, a year-long processing times of one agency, you're not going to like the processing times of another agency, right? You're just not. If you get a notice of intent to deny, you've got 33 days to handle it. So if that is an issue, I would say to anyone, work with an attorney and, and then you come up with, a reasonable plan of attack that you are doing most of the work prior to filing. And remember, and you may not know this, but when we file an application, there's this rule that says the application must be approvable at the time of filing. So if you wait to get that payment plan, if you wait to start paying your alimony, and you wait until we get an RFE, you're like, oh, I'm not going to worry about it. I'm just going to wait to see if they ask for it. They can say your payment plan wasn't in place as of the day that you filed. So on the day of filing, you were actually not approvable. And that becomes a waste of your time, effort, energy, and money when you could have dealt with it before filing. That is the kind of strategy analysis that working with an attorney becomes very beneficial for your case. So just keep that in mind. What's the number one strong evidence for an exceptional hardship or waiver application? So there isn't any one. There is no one piece of evidence. For applications that are flexible, that offer you an opportunity to determine or give the Immigration Service what you think is helpful for them to decide. So I'm not talking about an H-1B where, I have to provide evidence of an academic background. I'm not talking about a marriage-based green card or an I-130 where I have to provide a marriage certificate, right, to show that these two people are married. That just has to be there, right? But in a waiver situation or in a extraordinary ability application or in a national interest waiver, there's a certain amount of flexibility that we have in what evidence we provide. It all goes back to what documents are relevant to your specific situation. It is not this piece of evidence is number one on their list, this piece of evidence is number two, this piece of evidence is number three. That's not how it works. They want to see documentation that backs up your personal situation, which is going to be different than every other situation that they are looking at. So hopefully that is helpful. And hopefully that dispels a myth. I'm married over 12 years and I'm assuming continuing to stay married. Is USCIS still questioning during the citizenship interview? Citizenship is the biggest benefit that the Immigration Service provides. They will ask you all sorts of questions. It is the biggest benefit that the agency provides. It is not, citizenship is an application they do not take lightly. So yes, they can ask about, your marriage. They can go back and look at your green card application. They can go back and look at your student application. They do, and they will. So nothing is sort of off the table. So that is, someone is saying they work like brothers and sisters, and I'm wondering if that is a comment in response to one agency is not going to give you a benefit if you are not square with another agency. And I often didn't use the brother and sister context when I am chatting with my clients. So if that's what you put that in there referring to, that is funny. So that is all I have for you guys tonight, to be honest. I'm going to go make some dinner and eat and send out, as always, a few more emails that I did not get to earlier today. I will be back again live tomorrow. I usually go live Monday through Thursday, although this week, it's usually Monday through Thursday at 7-ish p.m. Eastern Standard Time, although this week, Wednesday, I will not be going live. I have a meeting that I have to be at in the evening. So if you would like to come back tomorrow and we can chat some more, that'll be great. I always start off with some updates, some immigration updates. So immigration updates, I think, are helpful for people to know about. And if you want to work with the firm, you want to work with me and my team, you're welcome to click the link in the bio, schedule a consult. All of my clients they've always started with a consultation. I've got to know what the facts are, ask some questions, give you an opportunity to ask me questions. And then that is a time that helps me provide you with an initial strategy of your case. So I work with clients. I am in Florida, but I work with clients all over the US, in all 50 states and DC, as well as internationally. And while I am an attorney, I'm not your attorney yet. So if you want me to be your attorney, then you've got to click the link in the bio, set up a consultation, and then we are off to the races. I will be back. I will chat with you again tomorrow with more updates. Have a great evening. Enjoy some downtime, and I will be back tomorrow. And thanks for all the gifts and the stars and the emojis, y'all. I really do love them. I will talk with you tomorrow. Bye. There.